Viewers, this video is about the center-state legislative relation. This topic is important for the civil service preliminary exam GS Paper 1 for the Indian Polity part, and also the GS Paper 2 of the mains paper, and the political science optional paper 1, and also the second paper of the public administration optional subject for civil service examination. So all we know that India is a federation with strong centralizing tendency. It is a Canadian type federation with purposely making center stronger one. However, it is not a strict federation, it is a semi-federal or quasi-federal type. So federal nature of India is not static one, it is a dynamic one. So India is a dynamic federation. So this dynamism is reflected to the center-state relations. So center-state relations, there is relation between the central government and state government. So it can be categorized under three headings: the center-state legislative relations, the center-state executive relations or administrative relations, and the center-state financial relations. Part 11 of the Constitution deals with the center-state legislative relation and center-state administrative or executive relations. And Part 12 of the Indian Constitution deals with the center-state financial relations. So center-state relation is required because both center and state together perform the respective functions of the governance, and it is altogether functions of the entire nation or entire Indian political system. So the center-state legislative relations can be categorized under certain headings. Firstly, the territorial arena of the union and the states for their legislative functions. The distinctive legislative subjects assigned or entrusted to the central government and state government under three lists, namely the union list, state list, and concurrent list. And also there are some areas where union have exclusive rights over certain functions mentioned in the state list. Besides, center can also control over the state legislature in certain cases. And fifthly, there are certain criteria in the center-state relations where the union or center enjoys superior status over the states. So all these features together analyze or explain about the nature of the center-state relations in terms of legislative features in Indian political system. So now let's discuss details about it. So in territorial arena, the parliament can make law or its legislative extension ranges from any part of the Indian territory or in the entire Indian territory, or it may influence the people of Indian origin or Indian people living beyond border. That is the parliament's legislative actions. It extends not only within the Indian territory, but it has an extraterritorial character. That the people living in any part of the world who are of Indian origin or Indian citizen, those can also be influenced from this law. On the other hand, the state assemblies has the power to make law for any part of the respective state or within the respective state's boundary. Article 245 deals with this matter. However, the laws made by the parliament have certain exceptions in case of certain areas, especially the union territories and the tribal areas and tribal tracts of the Assam, Meghalaya, Tripura, and Mizoram. Article 245 to Article 255 deals with the legislative relation between center and the states. There are certain distinctive lists of subjects to be legislated by the center and the state. And this list are the union list that comprise originally 97 subjects and now 100 subjects, over which the parliament or center has the exclusive right to make legislation. This subject includes defense, banking, railways, airways, insurance, communication, trade and commerce, audit, election, and so on. There is another list called state list. It consists of now 61 subjects. Originally there were 66 subjects. So subjects have been reduced to 61 now. So states have the exclusive right to make legislation over these subjects. This includes some common subjects like public order, police, public health, sanitation, agriculture, local government, fisheries, market, theatres, and so on. There is another list that is called concurrent or common list. The subject matters of the concurrent or common list, these are performed by both center and the state. The subjects like education, forest, weighted measures, protection of animals and environment. So such subjects are mentioned in the concurrent list. Article 248 deals with another list of functions that is called residual powers. The functions which are not included above in the above mentioned three lists, namely the union list, state list, and the concurrent list, these are included in the residual powers. And the parliament has exclusive right over the functions of the residual powers. There are certain areas where union can exert exclusive rights over certain functions of the state list. For example, according to Article 249, Parliament can make legislation in the name of national interest over a subject of the state list. For that purpose, the Rajya Sabha have to pass a resolution by special majority, that is the 2/3 majority, to transfer the subjects of the state list in the name of national interest to be legislated by the parliament. According to Article 352, with a provision of national emergency there, when a national emergency is declared under Article 352, then the entire functions of the state list are to be performed by the parliament. So parliament has the exclusive right during the time of national emergency to legislate over subjects of the state list. When there is state emergency, or also called the constitutional emergency, under Article 356, the state government may be suspended or dissolved. During that period, for that particular state, the subject matter of the state list are to be legislated or has been legislated by the parliament. So in these cases, the parliament has the exclusive rights over the state list than the state assembly. Sometimes two or more states also make a resolution so that certain subjects which they have that particular state that they cannot perform or cannot legislate over it due to certain factors, then they can request the center to make legislation over it. So once the two or more states pass this legislation, then the parliament enjoys the right to make legislation over the Sanskrit. Such a law can be applicable in other states also, if those later states can also make a resolution afterward. And sometimes to implement some international treaties, international obligations or agreements, then also parliament can make law over a state subject, if that subject are required to fulfill the norms of the international agreements or treaty obligations. There are also certain provisions through which center always can keep control over the state decisions. For example, the governor of the states can reserve certain bills passed by the state legislatures to be considered by the president or the center. Similarly, there are certain bills. Before passing it in the state legislature, the prior consent of the prior sanction from the president is required. If any financial emergency is going on, however, there is no financial emergency so far in India, but if there will be a financial emergency, then the money bill or any financial bill of the states have to be passed only after prior recommendation from the president. There are also certain provisions which directly ensure or establish superior status of the union over the states. For example, according to Article 169, the Parliament has the power to create or abolish the second chamber of the State Assembly, that is the Legislative Council or Bidhan Council. So, state legislature can be either unicameral or bicameral. Unicameral means consist of one house, just like Legislative Assembly only. And bicameral legislature means the existence of two houses in the state legislature, the Legislative Assembly and Legislative Council or Bidhan Council. But the Parliament can only decide in which state Bidhan Parishad or Legislative Council can be established. Or Parliament has the exclusive right to abolish any Bidhan Parishad in particular state where there is bicameral legislation. So in this way, Parliament has the upper hand or superior position to influence the basic structure of the legislative organs or legislative pattern of the state legislation. And the similar feature is there according to Article 3. The Parliament has the exclusive right or power to alter the names and boundaries of the states. The territorial boundaries of the states can be changed or altered or divided by the Parliament alone. So all these features reflect that there is a legislative relation, but it is dominated by the center in our federal system. But this arrangement is required, it is a purposely made arrangement so that we have a stronger center and weaker state, so that the national integrity can be ensured.